Start. The trial court erred in dismissing the joint application filed by the parties under Section 13B of the Act. The respondent wife has no locus or competency to withdraw her consent after the period of 18 months specified in Section 13B of the Act. The trial court as well as the division bench of the Bombay High Court, which heard the latter's patent appeal, overlook the crucial words occurring in Section 13B in bracket 1 and 13B in bracket 2 of the Act. Under Section 13B in bracket 1 of the Act, a petition for dissolution of marriage by a decree of divorce should be presented by both the parties together, but under Section 13B in bracket 2, for making the motion for passing a decree after the period of 6 months, both the parties need not be present. In this case, the joint petition for dissolution of marriage by a decree of divorce was presented by the husband and wife together in compliance with Section 13B in bracket 1 of the Act. All the three ingredients were satisfied when the joint petition was filed by the parties, namely that they have separated for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed to dissolve the marriage. The motion for passing a decree was made after 6 months of the date of presentation of the petition by the husband, for which the wife had notice, and this is sufficient compliance of Section 13B in bracket 2 of the Act, since the wife has not withdrawn her consent within the period of 18 months after the date of presentation of the petition. The trial court was obliged to pass a decree of divorce after hearing the parties, counsel or both sides place in their respective interpretation of Section 13B of the Hindu Marriage Act. Section 13B of the Act reads as follows: subject to the provisions of this Act, a petition for dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the Marriage Laws Amendment Act 1976, on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved, on the motion of both the parties made not earlier than months after the date of the presentation of the petition referred to in subsection in bracket 1, and not later than 18 months after the said date, if the petition is the said date. If the petition is not withdrawn in the meantime, the court shall, on being satisfied after hearing the parties and after making such enquiry as it thinks fit, that a marriage has been solemnized and the averment in the petition are true, pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree. Mr. Yadav, counsel for the respondent, heavily realized the decision of this and contended that it is open to one of the parties at any time till the decree of divorce is passed to withdraw the consent given to the petition, and mutual consent to the divorce is a sine qua non for passing a decree for divorce under Section 13B of the Act. Mutual consent should continue till the divorce decree is passed. It is positive requirement for the court to pass a decree of divorce, since this crucial or vital aspect is absent in this case. Counsel argued that the matter is concluded and that it is unnecessary to consider the other aspect urged regarding Section 13B of the Act, or to focus attention on the totality of the circumstance to consider whether any other appropriate order should be passed by this court at this juncture.